professional considerations in MC issuance. And next, we'll have Mr. Charles Lin, who will talk about the legal framework and medical legal responsibilities. We'll then have a break and we'll come back to have the second part of the webinar. We'll have a case-based discussion led by Dr. Sarah from MPS, Medical Protection Society Singapore, and we'll finally end the webinar with a panel discussion and Q&A. So without further ado, let me invite President Dr. Wong to give the opening address. President, over to you.
Thank you very much, James. Good afternoon, everyone. And on behalf of the College of Family Physicians Singapore and the Medical Protection Society, I would like to warmly welcome all of you to this webinar, Medical Certification, Duties, Risks, and Legal Pitfalls for Family Physicians. Now, medical certification is one of the most common tasks performed by doctors in everyday practice. We often think of MCs for the purposes of sick leave, but we also do medical certification for fitness to work or to school, insurance examinations, and statutory medical examinations such as for driving license renewal and 6-monthly domestic helper checkups. MCs for sick leave is the most common and the focus of this afternoon, but it should also be seen as part of a continuum of medical certifications. In all such instances, we as doctors are called upon to make professional judgments that have consequences for patients, employers, and society. What is unique about medical certification is that it represents a professional privilege entrusted exclusively to doctors. When we speak of a professional privilege, we don't mean a benefit or an entitlement. Rather, it refers to a special authority granted to a profession by society because of the trust placed in our knowledge, ethics, and ability to self-regulate. You see, medicine is built upon a social contract between the profession and the society. Society grants doctors powers and responsibilities that ordinary citizens do not possess. These include the authority to diagnose illness, prescribe medicines, access confidential information, certify illnesses and incapacity, and make judgments that may affect a person's employment, education, and insurance claims. For example, no other person other than a medical doctor has authority to pronounce death. And this is the focus of another webinar we have next weekend. But as they say, with such power comes great responsibility. Society expects doctors to place patients' interests above personal gain, exercise independent, unbiased professional judgment, act honestly and ethically, and remain accountable. Medical certification is perhaps one of the clearest examples of this social contract in action. When a doctor signs an MC, employers, schools, insurers, and even the government generally do not have to verify the diagnosis independently. They accept the MC because they trust that the doctor has conducted an appropriate clinical assessment and exercised honest professional judgment. So you can see that the whole process of medical certification is in essence about trust. It's about public trust vested in the medical profession. Every inappropriate MC issued weakens that trust. And the problem with that is that even if you are doing the right thing, but another doctor isn't, the other doctor's actions affects you. We therefore have to always remind ourselves that medical certification is far more than an administrative task, but an exercise of professional responsibility. As family physicians, we are expected to issue MCs only on proper medical grounds, following an adequate clinical assessment. Yet, we also know that certification is not always straightforward. Family physicians frequently encounter requests for backdated certificates, pressure from patients, uncertainty regarding fitness for duty, and situations where clinical judgment, ethical obligations, and legal considerations may come into tension. What appears to be a routine task can sometimes expose doctors to complaints, disciplinary proceedings, and even medical legal risk. It's therefore essential that we understand not only the clinical aspects of certification, but the ethical, professional, and legal principles that govern our practice. So that's why we're all here this afternoon. This evening's webinar provides an excellent opportunity for us to learn from experts in the field, reflect on common challenges, and strengthen our understanding of the responsibilities that accompany this important professional privilege. I'd like to thank our speakers and organizers for putting so much effort for this timely and highly relevant program. Thank you for joining us this afternoon, and I wish everyone a fruitful and engaging webinar. Back to you, James.
Thank you so much, President. So without further ado, I'd like to move on to the first speaker. Our first speaker is Dr. Lawrence, who is an accredited family medicine specialist, and he'll be talking to us on ethical and professional considerations in MCs. So just a little bit about Prof. So adjunct professor, associate professor Lawrence Ng is a specialist family physician with over 30 years of clinical experience, and is accredited by the Ministry of Health Singapore. He was awarded a fellowship of the College of Family Physicians Singapore in 2017, where he received formal training in medical ethics and professionalism. Dr. Ng previously served as a medical legal consultant with the Medical Protection Society Singapore, providing round-the-clock medical legal advice and support to thousands of doctors in Singapore. He has extensive experience as a medical expert witness and has provided expert opinions in cases before the Singapore Medical Council, acting on behalf of both prosecution and the defense. And a passionate educator, Prof. Wong is actively involved in teaching family medicine at the Duke NUS Medical School, and he has also authored numerous publications on medical ethics, professionalism, and medical legal issues in clinical practice. So without further delay, over to you, Prof.
Okay, thank you very much, James. I shall start my clock at 25 minutes, where I will end by 3:40. Can you see my slide?
Not yet.
Okay, can you see my slide now?
We still waiting for that.
Okay. All right. Can you see my screen?
Yes, we can.
Okay, thank you very much, James. Okay, today's talk is very important, and we're talking about MC, something that all of us do, whether we're specialists or we're GPs. And MC has been in the spotlight recently in the news, especially last year and the year before, about giving too much MCs, and the year before that was giving too little MCs. And actually, MC has been given even by the ancient Egyptians, and what we call paid sick leaves, paid sick leaves. So the content of my talk is into three parts, actually. What is MC, and what are the problems and burdens for GPs with MC, what I call the dark side of the moon. I present to you some research data that I found, Singapore and Malaysia. And then the main course for today is about the ECEG, what is our duty. And if we have time, then we'll talk about the worldwide GPs' views on MCs, some possible solutions to the problems and burdens. So the the Singapore Medical Council Ethical Code and Ethical Guidelines is the main talk today, but it only tells you what you have to know. And today I will tell you what you need to know. So the MC in Singapore refers to what is known as a sickness certificate or the sick note. Some people call it sick listing. In Singapore, only medical practitioners can issue a medical certificate, and it carries certain obligation. Conversely, on the flip side of the coin, there's also a fit note, which has started in the UK in 2010, certifying fitness to return to work or to school, such as what we had during the pandemic. This is an important concept in occupational, social, and psychological medicine. So a question was asked recently, on what basis, what legal basis do we give MCs? And actually, it is actually enshrined in two laws in Singapore. One is the Employment Act in 1968, which says that the worker or employee can present himself for paid sick leave, only when certified by a GP. Then on the right-hand side, you can see that under the Medical Registration Act of 1997, or the MRA, in the yellow box, it says here a certificate, MC, can only be issued by a medical practitioner. So when you put these two together, the employer is not bound to accept MC that is not certified by a GP. So actually, it's in the law, the TCM cannot issue MC. So what is an MC? So an MC actually, what is MC versus the fit note? So the fit note actually is something that's I want to talk a bit about, because we usually certify a person or patient not fit to go to school or go to work after a certain time, but we seldom certify them back to work, to return to work. And this has been written up by Colonel Dr. Brian C. in the Annals of the Academy in 2017. And he says that actually keeping a patient away from work is detrimental. And it says in the right-hand side paragraph that anything more than 7 days actually is detrimental to the worker. So the MC is actually a legal document. And then it is also a piece of communication tool for you to communicate with, to be given to the patient, and the patient gives it to the employer, the human resource officer, the schools, can be armed forces, police, customs, immigration, insurance, and even to the courts. However, it is also confidential. So especially when we are dealing with third-party stakeholders who are non-medical. Now, the key point to make here is that while there are many stakeholders involved, your duty of care as the doctor treating the patient is to the patient. And what is this duty? This duty is to act in his best interests in the majority of cases, and public interest in some cases, such as in pandemic, for the prevention of harm to others. Now, the MC actually is a task that a lot of doctors find, to put it mildly, troublesome. We are vested with the authority to issue MC, and the MC has got normative, that means a set of rules, normative connotations, carries obligations and responsibility. However, this story has a far side of the moon, which we GPs know but seldom talk about. And the issue of MC, the problem of MC is the problem of gatekeeping, the gatekeeping role, which is fraught with daily difficulties for practitioners on the ground. And by the far side of the moon, I mean the side of the moon that is unseen from Earth. It is also called the dark side of the moon. And why is this so? Because doctors, patients, and other stakeholders, we are imperfect people who live in a complex and imperfect world. Imperfect people using MC, which is also an imperfect system for paid sick leave. So there is also a human side to medicine, what we call the art of medicine. Now it's called medical humanities. So medicine is an art as much as it is science. It is practiced with the mind, the cognitive, as well as the heart, the affective. And it often calls for judgment. And decisions may not always be based on hard logic. The diagnostic pathways and how decisions and judgments are arrived at are not always documented. And sometimes how these cases become indefensible when scrutinized because there's no documentation. And then the actions may be deemed as unjustifiable. Now, it is in the qualitative research that we find the problems in the art of medicine and MC issuance. And I give you here 6 references. They're all very good to read if you have the time. If you don't have the time, you just quickly listen to my talk, and then we'll figure this out. So indeed, like Top Gun Maverick, Tom Cruise Maverick says, time is the biggest enemy in a medical consultation. We often teach the students some models for consultation, and one of them is called Pendleton. And for those of us who teach family medicine, we know there are 7 tasks in Pendleton. And nowadays, we also have to do what is called the HSG tasks, data submissions and all that. And MC is just one of those tasks competing for time in a busy clinic. It has been written in one of those articles I quoted that it is faster to acquiesce to a demand for MC than it is to work out the reasons why a patient should not be getting an MC, or why is he asking for an MC. So I repeat, in any clinic, time is the greatest enemy. So here you can see penalties 1 to 7, the task, and actually task 1 has got 4 components, task 2 has got 2 more components. So where do you find the time? And this is the problem. Where do we find the time? The other aspect of MC, the dark side of MC, is that biomedicine, is this the only game in town? Now, it has been written in the ECEG that MC is only to be given on medical grounds. The question that is raised sometimes is MC confined only to biomedical grounds? As we know from Engel's biopsychosocial model, the triaxial model of illness, there's biological, there's social, and there's psychological. Can all these be grounds for MC as well? The other problem is MC is to be given arising from a doctor-patient relationship. This is written in the Singapore Medical Council, ECEG. It is also written in many other medical councils, including the Indian Medical Council, the Malaysian Medical Council. However, herein lies the conflict between the dual role of the healer or advocate in a trusting therapeutic relationship versus the assessor, the medical examiner, or the gatekeeper role, as written by the author Parvin. The gatekeeper role is often the source of the problems. Why? Because we begin with empathy in a patient-centered and respecting autonomy mode, and then at the end, we move to a paternalistic logic and judgment mode when issuing MCs. Almost paternalistic, So this is one reason why MCs are viewed by GPs as problematic, complicated, and burdensome. These are the words used in the literature. It can be an unwelcome daily challenge, often thankless and exhausting, and leading to burnout. And I still remember a lot of us when we're choosing our specialty, one reason why many choose against family medicine is because it is seen that every day you have to deal with MCs. And there's some truth in this, I shall show you. So this is an article by Parvin that MC is more than just paperwork. And he says here, the problem is A versus A, the assessor role versus the advocate role. One moment you're the advocate, next moment you're the assessor. This conflict is the biggest issue in issuing MC. And so the other issue is that there's lack of support and training about the issuing of MCs. And I feel that it should start before a junior doctor starts his career. On a given day, most MCs are issued by primary care physicians, whether you're polyclinic doctors or your private GPs. And these MCs in primary care are usually issued for minor illnesses, for short-term and not long-term disabilities. I will quote David Ng's article later. Most of the time, MCs by us are often all or none and not involving light duties. Sometimes they can, Serious illnesses requiring longer MCs are usually referred to hospitals or associates. I would like to draw this distinction because there are some sensational SMC cases that went to High Court for appeal, but these usually involve orthopedic injury cases, and they require MCs followed by light duties. And then there are a lot of questions regarding the light duties. So this is an excellent paper by David Ng and many other authors. And it is actually a cross-sectional study of 1 week of all polyclinics MCs issued in that 1 week. It does not include GPs, and that's the limitation of the study. So what's the data? The data shows that 22.6% of the attending patients got MCs. 22.6. That's almost 1/4. 1 in 4 patients seeing the polyclinic got MCs. And the average MC is 1.4 days. Okay, 1.4 days. So this is quite important to bear in mind. And these are the top 10. You look at the right side here. The right side has got the top 10 with MC or sickness certification. And out of the top 10, I draw your attention to the top 3, which is acute URTI, 30%, musculoskeletal, low back pain and all that, 12.5%. GI symptoms, gastritis, dyspepsia, 5.7%. Headache, quite close, about 4.9%. And I'd like to point out that, do you notice that none of these are psychological in origin? None. And in overseas, the data is different. There is a huge proportion of MCs that will be issued for psychological illnesses. So I guess we are more biomedical here than in overseas where they are also orientated towards psychological medicine. Okay, in Malaysia also, they have some studies, and the Malaysian author here wrote that physicians are reluctant to perform the role of gatekeeping, that means issuing MCs, and they find conflict. And in fact, they found that it's a lot of emotional strain. And then UK and European countries have actually found there's an abuse of MCs. And in fact, okay, I don't have time to put it into my slides. In Germany, they have just stopped this method of self-certification. That means you can call up for the first 3 days of the working year, and you don't have to produce the MC. You just say that you're sick, you don't come in. And Germany has just abolished it. Yeah, no more self-certification in Germany. So I would like to present some guardrails for issuing of MC, how to stay out of trouble and know your duty. This is the main course that you have to listen to. And I would like to thank Prof. Devan from SMA and SGH, the Medical Humanities Institute, for providing some of these slides. So this is the most important slide. In fact, everyone should just screenshot this slide and then you can go home already, you know. But you must read every single point of B4 of this ECEG 2016, okay? You have to read every single word and know everything about this slide. Okay, I will go point by point. Now, the points that I would show in gray would be from the Handbook on Medical Ethics. Later, I'll talk to you about it. So MCs must be issued only on proper medical grounds, arrive at good clinical assessment. By clinical assessment, they mean history taking and physical examination. It applies also to telemedicine, but of course, the physical examination is somewhat different. You know, MCs are issued either to promote the recovery of the patient or to protect third parties from possible harm, such as infectious disease, like for example, during the pandemic, or if you got, you know, even something as innocuous as head lice or hand, foot, and mouth, which is not innocuous, it can kill. But you must not take into consideration any other extraneous factors. So who pays for the consultation, whether it benefits the patient, such as NS man, or whether the employer's preference, whatever the preference may be. And recently in the news, the question of whether more MCs are being issued, is it caused by telemedicine? Or are there any other factors? So this is still a perennial question. And in fact, many of the MCs issued by telemedicine providers and the doctors involved are being referred for further investigation, such as by Singapore Medical Council. It's interesting to note that in Malaysia, the Malaysian Medical Council, as of 23rd September last year, has said that it has decided that the issuing of MC solely following a teleconsultation is not allowed. So Malaysia has banned it, to the point that failure to comply may result in being subjected to disciplinary proceedings by MMC. Now, I have checked this with another doctor in Kuala Lumpur, and he confirmed that it's still in force. And actually, the MMA, the Malaysian Medical Association, endorsed this as late as November last year. So I believe it is still in force. So this is an example of the telemedicine portal being investigated. License was revoked for Mana Doctor Clinic for inappropriate practices, for short teleconsultation duration, for multiple MCs being issued for questionable and poor documentation. And the Ministry of Health will be auditing, monitoring other licensed providers of outpatient medical services via teleconsultation. And to the point that many circulars were issued by Ministry of Health on the issuing MCs via telemedicine. This is just about 2 years ago, so it's still ongoing. Okay, I read again the MOH circular. It says that integral to the issuance of an MC is that it must be made in the context of an existing patient-doctor relationship and is based on the duty of care that the doctor owes the patient arising from this patient-doctor relationship. The issuance of an MC under particular circumstances is not a standalone activity that can be divorced from, but is instead reflective of the duty and standard of care that the doctor must uphold in their management of patients. A mouthful of words, but basically it is part of the duty that you provide to the patient. Feedback from the employers and other government agencies regarding excessive issuing MC, particularly in context of teleconsultation. The next point you must note is MC issued solely based on the patient's self-reported reasons that they had input into the teleconsultation platform without proper assessment by a doctor to determine if there were indeed any other underlying health conditions which warranted the MC. So the issues of whether or not self-reported reasons are good enough, and then non-medical reasons. So MCs that were issued for people who want to skip work at school or school, but they were not sick. And abuse of medical leave privileges. Repeatedly, MCs were issued without referring them for physical consultations for further assessment. B4.1, MCs must be issued to patients only on proper medical grounds, arrive at good clinical assessment. Okay, the one in gray is not in the ECG, but it's in the Handbook of Medical Ethics. Unless there are clinical reasons, well, patients who consult you should only be given MCs for attendance, that means certificates of attendance, not MCs. Using sick leave to attend a doctor's appointment. I think this one will cover in the Q&A. I don't have the time. MOM is quite supportive, but sometimes we are a bit harsh on ourselves. The B41 says that it is inappropriate to issue MCs of too short a duration, too short for recovery, and yet there's also issue of issuing MC too long, Okay. B42, MCs ought to be given directly to the patients and no other parties. Then it's for the patient to then hand it over to the human resource or the boss. MCs must be written objectively, accurately, in good faith, and cover the appropriate duration. And where relevant, accurate account of the patient's limitations during the period covered. Okay, attendance of court, I will leave it to Charles. This is about attendance to fitness to attend court or unfitness to attend court. Okay, if you are certifying the patient's fit to return to work, you must certify fit to work, but with limitations on the level of activity. To the best of ability, you need to be assured that the patient's work conditions allow this, and duties appropriate to limitations are in fact available. This covers the question of light duties. So if you issue light duties, you must ensure that there are light duties for the patient to do back at work. So you can ask the patient and then document down that you ask the patient, or you can call the employer or the supervisor and ask them what appropriate light duty is available. If light duty is not available, the appropriate light duty is not available, you should then order complete rest. That means give them the MC. Post date the MC, no, you cannot post date or back date the date of issue. The date of issue must be on the day of the consultation or the treatment. But if you want to start the coverage of the MC before the date of issue, that means before the patient saw you, you can, but it must be consistent with the clinical presentation or the illness. So then you must document it down, So when it comes to the date issue, do not post date, do not backdate. Okay. Then any MC issued by another doctor, you must not amend it. You can reassess the patient, and then you can issue a fresh MC. So it also helpful if you can discuss the case with the doctor who issued the original MC, and for you to understand their rationale for issuing the MC. So you must not amend the particulars on the MC And if you disagree with the MC issued by another doctor, you can issue a fresh MC. But it's only after you assess the patient yourself to determine that this is justified. Diagnosis must not be stated on the MC unless you have the patient's consent. Okay, diagnosis must not be stated on the MC. Don't write your diagnosis on the MC. As with all third-party disclosures, the patient needs to consent to the disclosure, but sometimes employers will contact the doctors to try to find out more about the patient's condition. And unless you have the patient's consent, such information cannot be revealed. So whether you want to pick up the telephone and speak to the human resource officer, that's up to you. How confident you are of not breaching the confidentiality. And you must sign the MC personally, okay? Because you are personally responsible for it. This is a new healthcare regulation under HACSA in 2024, which then state that the name of the medical practitioner or the dentist must be given, and the registration number, so the MCR number. And if this applies also to the electronic MCs, there's one portal called mc.gov.sg. This is to ensure that there is no fraudulent issuing of MCs. Hospitalization MC, now this is a big one. Suffice to say that at the moment, only specialists who can admit a patient into any facility are able to write such MC. So for most of us GPs, we are not allowed to write in the hospitalization MC. Pregnant women, if they have medical indications that require hospitalization, regardless of whether they are warded or not. Patients undergoing chemo or radiation therapy will require rest but not warded. Post-day surgery, medical inpatient care at home, quarantine orders, this can be issued hospitalization MC. So this is coming to my last slide. So take the issuing MCs very seriously. MCs are to be issued on proper medical grounds, arrived through good clinical assessment. How you deal with inappropriate requests, like we all know, there are certain steps, but I won't cover it today. And then the issue of light duty, and then never post that a bad date, the date of issue of MC, and that any fraudulent MC is always treated very seriously. So this is into the next slides will all be on problems and difficulties, but I will not cover it for lack of time. I hand you over to the chairman. Thank you.
Thank you very much, Dr. Prof. Lawrence, for sharing with us and sharing us of the insights regarding the difficulties that GPs face on the ground with regards to issuance of MC and also the professional and ethical obligations that doctors have when it comes to issuing MC. I see some questions being posted on the Q&A. Please continue to post them and we'll take them. So thank you very much, everyone. So we'd like to move on to the next speaker. We have with us Mr. Charles Lin, who's the Managing Director of Charles Lin LLC, to speak to us on the next topic, which is regarding medical certification, legal framework, and medical legal responsibilities. So just a bit about Mr. Charles. Mr. Charles Lin obtained his Bachelor of Law honours from the University of Buckingham and was called to the English Bar in 1989 as a member of the Middle Temple. He's an advocate and solicitor of the Supreme Court of Singapore and also serves as Commissioner for Oaths and Notary Public. Mr. Lin commenced legal practice in 1989 and joined a leading medical legal and dental defense firm in 2011. And since 2017, he has been the director of Charles Lin LLC. With more than 35 years of experience, Mr. Lin is widely recognized for his medical, dental, legal, and healthcare law practice, representing doctors, dentists, healthcare institutions, and medical professionals in disciplinary, regulatory negligence, and professional misconduct matters before the courts, the Singapore Medical Council, and the Singapore Dental Council. He also serves on the Law Society of the Singapore Advisory Panel for Medical Law Reform and remains actively involved in pro bono and humanitarian work, including medical mission trips to Myanmar. So we're very privileged to have Mr. Charles with us to share with us on the next talk. Charles, over to you.
Thank you, James. You're most kind. Thank you, everyone, for taking time off this Saturday afternoon to attend this very interesting webinar. I will first start with the power to issue medical certificates. Next slide, please. Within the Medical Registration Act, Part 3 is entitled Privileges of Medical Practitioners. We can say that the power to issue medical certificates sits within this part. Section 13 sets the basic rule. A person must not practice medicine or do any act as a medical practitioner unless registered under the Act and holding a valid practicing certificate. Section 15 is headed Medical Certificates. This is the specific provisions dealing with the MCs. It recognizes the legal validity of medical certificates signed by registered medical practitioners. While it does not itself confer a standalone power to issue MCs, it provides that where a written law requires a certificate from a duly qualified medical practitioner, the certificate is valid only if signed by a registered medical practitioner with a valid practicing certificate. Now, Section 16 clarifies that a certificate is to be signed by a legally qualified medical practitioner or duly qualified medical practitioner. This expression means a person registered under the MRA with a valid practicing certificate. This is the key linking clause. It is what makes an MC signed by a SMC registered doctor legally recognized across all the other legislation that reference sick leave certificates, sick leave fitness certificates. All in all, registration as a doctor alone isn't enough. The doctor also needs an annual renewed practicing certificate issued by the SMC before they can practice, including issuing medical certificates. In short, the legal power comes from the MRA. The rules on how to exercise the power responsibly comes from the SMC Ethical Code and Ethical Guidelines. Now, what are the considerations? Next, please. What are the considerations for a medical practitioner when issuing a medical certificate? Lawrence has cited Guideline B4. A medical certificate must be based on clinical decision, and you must arrive and must be based on proper medical grounds, arrive through good clinical assessment. Now, before I go on the common allegations, I would like to tell you what the SMC requires in terms of certificate and medical certificate. What I say now is actually an extract from an actual SMC case on telemedicine, but it would apply equally to general practitioners. Now, what does the SMC expects a medical practitioner to do before he issues medical certificate? You must prove that you have taken time to assess the patient visually to determine if the patient appeared drowsy, disoriented, or toxic. You must obtain a detailed history for the ailments complained of during the consultation. You must pose relevant questions to check if the patient was feeling weak or numbness in any area of the body. If their vision is blurred, if there are any fevers or rashes, and if they were experiencing any giddiness or loss of consciousness prior to the consultation. Check if the patient has any prior allergies or any form of medication. Formulate medical diagnosis based on clinical reasoning from the history obtained and visual observations of patient during the consultation. These are what you will need to justify if you are faced with a complaint to the medical counsel. The medical counsel will expect you to have covered all these points, and your notes must properly document these points. So what are the considerations that we often face in complaints against medical practitioners for issue of medical certificate? Complaints are that the patient wants the medical certificate, that the person paying for medical certificate or the consultation try to influence the issue of the medical certificates to make sure there is benefit to the person paying rather than the patient. For complaints that durations are too short, we always get the common complaint that the doctors are influenced by the employers not to issue too many medical certificates or too long a medical certificate. We actually had a case where the employer, where the doctor was faced with a complaint to the medical counsel. Now, the doctor was quite innocent, what happened was that the patient had served his notice of termination employment, taken leave, but needed medical certificate to cover the extra portion of the leave to the end of her employment date. She did not tell the doctor this. She went to see the doctor and told the doctor, I'm not well. Can I have 3 days MC? The doctor, after examination, gave the patient 3 days MC. And a few months later, there was a complaint from the medical, received from the medical counsel that the employer has complained that this patient had taken medical leave just not to appear at work site to end her notice period. So the doctor was caught out, and at the end of the day, we were able to convince the medical counsel that the patient did have some ailments, but it was a touch and go case because was there sufficient ailments? Was there a sufficient ailment to justify a medical certificate for 3 days? I will not touch on medical certificates issued by specialists for industrial accidents, but as Lawrence said, you are expected to know the circumstances in which you offer a medical certificate. And what's interesting for industrial accident cases, the most recent development is when there's an allegation that the medical certificates were not handed over to the patient as required by the ethical guidelines, but were handed over to a supervisor in the presence of the worker. The doctor didn't know about it because he's inside the room. And the other interesting development is that we have recent cases of patients rejecting medical certificates. But to be fair, these are mainly industrial accident cases. I will next dwell on next slide, please. Yeah, this is where I jump my talk that medical certificate must be given directly to the patient. It is your responsibility to the patient. It is the patient's responsibility to hand the medical certificates to his employer. You must not disclose the diagnosis of a medical certificate without consent. We often get employers calling up and asking what's the diagnosis. There is an exception to this for medical certificates for the state court. If you want to prescribe light duties, you need to make sure that you know what are the light duties available. You must prescribe the limitations as detailed as possible to help the employers understand what you intend to help the patient with. Remember, it is always what is the best interest of the patient and not what is in the best interest of the employer. If light duties, as Lawrence said, if light duties are not available or you're not certain, give the patient a full medical leave. Next. Okay, the state court medical leaves are a special category of themselves. Now, I have brought this up because I think it is based on the actual case, and I think it is good to bring it to the attention of general practitioners and other people, any other person who are asked to issue medical certificate to exempt a person for attendance in court. The recent case we have was that the medical practitioner did not comply with this practice direction and was handed a letter of advice by the medical counsel. So what's so special about this state court practice direction, which is reflected in the SMA guidelines? Okay. First, you must make sure your name and registration number is on the certificate, your clinic name is there, your contact details is there, your signature is there, and if no signature is required, then you must or state that no signature is required if the medical certificate is electronically generated. You must state to the effect that the patient is medically unfit to attend court and specify the dates. You must also specify the diagnosis, plus a brief description of symptoms and condition, forming the basis for stating that the patient is medically unfit to attend court, unless the diagnosis cannot or should not be disclosed. Now, you may say, would this breach the patient's your duty of confidentiality to the patient? My answer to that is that your medical certificate is given to the patient. It is for the patient to hand the certificate to the court. And you must date the medical certificate and clearly disclose the difference between the date where this date differs from the date of the consultation. So if he consults you on Monday and you and you are backdating the or forward dating the medical certificate exemption from court, you must explain why. Next slide, please. If you feel strongly that you need to add additional details, you can include this in the memorandum to the certificate. Now, your memorandum should be addressed to the judge, magistrate, or subordinate courts, or the judge, magistrate of the Supreme Court, not to whom it may concern. This will be consistent with the relatively new Section 39A of the Health Services Act for issuance of medical certificate, which was effective on 14 October 2024. Now, what happens if your medical certificate fails to comply with the State Court direction? Firstly, it may be rejected by the court. Next slide, please. There's a complaint to the SMC. There was an actual case where there was a lack of knowledge of proper medical documentation court proceedings. A memo was issued instead of providing a medical certificate. This is inappropriate. The party to the court proceeding lodged a complaint to the SMC, making various allegations. The IC investigating committee considered that the doctor acknowledged the mistake for issuing a memo, plus first time writing letter of such cases, issued the doctor a letter of advice. Teleconsultation case. What happened? The complaint was camera was not turned on due to technical issues. The doctor was not aware. Next case, please. Next slide, please. Consultation was conducted through a checkbox. Consultation completed within a minute. The MC was issued. The complaints committee looked at the case notes and came to the conclusion that the consultation was very brief. The doctor could not have conducted comprehensive history taking and adequate assessment. And this is where I has earlier stated, the doctor should have taken more time to assess the patient visually, obtain a detailed history of the ailments, complain out during consultation, pose relevant questions to check the symptoms patient may be experiencing prior to the teleconsultation, check if the patient had any prior allergies to any form of medication, check if the patient had any allergies that may display similar symptoms when aggravated, formulate a medical diagnosis based on clinical reasoning from the history obtained and visual observations of patient prior teleconsultation. Now, and most importantly, all this should have been documented in the case notes. I know teleconsultation is very, very attractive. I myself use teleconsultation because it avoids going to the doctor. I don't have to go see a doctor. Medicine are delivered to my house. But for the medical practitioner, these are the minimum the SMC expects you when carrying a teleconsultation. I have no further input unless there are any questions.
Thank you, Mr. Charles, for sharing with us on the legal aspects, and I hope that has also given us a better understanding about the legality surrounding MC. So this brings us to the next segment, which is at a 5-minute break. And right now the time is 2:55, so we're on time. So we could take a quick break, and we can come back at 3 p.m. Thank you very much.
Patient